All persons having the matter form of business for the Honorable United States Court of Appeals for the Fourth Circuit must draw nigh and get their attention. For the court is now sitting. Diocese of the United States in its honorable court.
All right, be seated, please. Or excuse me, I'm sorry. Judge Wilkinson is on our remote and he's presiding. I'm just sitting convenience of the camera.
All right, we're pleased to hear from you, Mr. Watkins.
Thank you, sir. I'm Bill Watkins, and I represent Mr. Fowler. Every time I go to the prison for a pre-sentence interview with probation, they explain to my client that they work for the court, that they are not really an independent agency. They don't work for the prosecutor. They don't work for me. And it is their duty to prepare a pre-sentence report that will help in the sentencing. In this case, the probation officer relied on those, I assume, some computer records in the PCR. It only said there was a ticket. And whether or not they are accurate, it added 1 point to his criminal history score. He went from a 2 to a 3 in the criminal history. The judge sentenced.
The 1 point was important to your client.
Absolutely, Your Honor.
And did you object to that below?
They did not. I was not the attorney there.
So it's raised up above and pursuant to the proceedings above, the government, which it could have done below, provided us with the sheet that shows that there was a trial and the person was found guilty.
There is a computer printout from the clerk of court in Greenville that indicates there was a guilty and he went to counseling. The problem with that is that that's entered by the clerk, and all that was in the PSR was a ticket. Now
I know, but my point is, had this been raised in the district court, this would have been uncovered. If it had been challenged, somebody would have said, "Oh, I'll take a look, we'll see what it is." No one had that opportunity. So we now have it, regardless of where it was provided by. We now have that information, unless you're saying that's a.
I'm saying that excuse me.
I was going to say, unless somehow you think that's a fabricated document, but I'm assuming that we can look at it.
I'm just worried about the accuracy of the document, Your Honor.
It's just a copy, isn't it?
You're worried about the accuracy or the completeness?
Both.
Okay. But you don't have any independent evidence to contradict anything that's on it?
No, sir. And now, the only thing that was raised in the court below was in the sentencing memorandum that was provided to the judge. The lawyer said that he had trouble getting information, but there was nothing in the oral argument.
That's the lawyer that filed the Anders brief?
Yes, sir.
Well, it still comes down. The problem is the plain error, because the pre-sentence report was clear that a CDV, which is a participation in a criminal domestic violence program, counts as 1 point. And that wasn't obscure. And the PSR made the finding that Fowler's CDV warranted a criminal history point. And there was never any objection to that.
Yes, sir.
And the point is, and I don't blame you at all for it, but you unfortunately have to adopt your predecessor's case, including any omissions. And, you know, we have so many cases that say, in the absence of objection, the district court is perfectly free to adopt that PSR.
Yes, sir.
I just don't see that there was any error at all under our precedent, much less plain error. It's just the plain error aspect of this. It bothers me.
Yes, sir. I believe and would argue that there is plain error on the part of the court, because they have the duty to make sure the PSR is accurate. Once they
no, the duty is to make sure that the duty is on the part of counsel to object to the PSR, that's the way the adversary system is supposed to work. And then we have our Terry case and many cases afterwards that say, in the absence of objection, the court is free to adopt the PSR. And the court did exactly that. How could that even be error, much less plain error, when the court follows our precedent on the point?
If there was clear, plain error in the PSR, then they have the burden to make sure that it's right. I think the burden shifts to the
Who's the
court.
they
I'm
in
sorry.
that? Pardon?
Court.
You're saying the court, the district court or this court?
No, sir, the district court. I
The
think
district
then
court had the burden to
to
get
make
it
sure
right.
that the PSR is right.
But the fellow was represented by counsel and the government was represented by counsel. And the probation officer getting it together, and it's on the lawyer.
I think the burden shifts to the lawyers to object, as Judge Wilkerson pointed out. But I think the initial burden is on the court to make it right and make sure that they are the correct documents.
But it turns out they were right.
I don't-
PSR was
I don't
correct.
know that. I don't know whether they were right or wrong.
Well, since the debate has shifted to this court,
Yes, sir.
we were provided with information to confirm that it was properly included.
You're talking about the clerk's document,
Yes.
which was available to the
I understand,
probation
but
officer.
you know, the pre-sentence report has a lot of facts and a lot of information. And there are, if we had to load up those pre-sentence reports with all the underlying supporting documents and testimony and evidence, it wouldn't serve the purpose. The better purpose is to have the probation office create a document with the best information they have, and then the attorney can object and they can dig further if it's necessary. But in this case, the PSR said there's 1 point for this offense, and there was no objection. And so the court included it. And then there's a challenge to that because there's not enough information and to confirm it. But now on appeal, after everybody for the first time is trying to address it, we have provided with a document that seems to suggest that the error didn't make any difference if there was an error.
I would argue that the document that was provided is not trustworthy. It is a document that was prepared by a clerk, and
It's
in
an
this,
official record. And
Clerks prepare
Clerk's
court
office.
orders all the time. Clerks file papers. Clerks certify documents and records. Is there any suggestion that the clerk here was untoward?
there's, I know of no suggestion that she didn't try to do what was correct.
But she simply made a copy of what occurred at trial.
No, sir, I don't know that that's true. That it's reported back to the clerk's office the way it practically works. And in this case, that record doesn't show whether they had an attorney or not. I may be,
They had a
I've had
trial.
experience.
They had a trial, didn't they? And
I don't know that,
following
sir.
the trial, the person was found guilty. It's a bench trial. That's what it says.
that's what the document says. That's not been my experience.
But how does your
Ain't in it.
experience
you
in
want
the
to,
record?
That means that I've done some of the CDVs, and what has happened is the judge has said, we'll dismiss this case if you'll go to counsel. That's not a conviction. I don't know what happened in this case. The record indicates, as you said,
It said a finding of guilt.
Bench trial.
you want us to read it, say that there was a bench trial of a pro se defendant.
I think that is fairly.
That's what you wanted to read.
Yes,
To be read.
And no
But I
finding
don't
of
know
guilt.
whether he had an attorney or not.
You,
Just something that's
well,
not in the record.
you want to mean that he didn't have it.
I would like you to believe that he did not.
Well,
I
you
would
got
assume that's the
you got
practicality of it.
a Gideon violation.
Maybe.
Maybe.
Again, I mean, obviously, if it, you know, it's. a situation-
We shouldn't be having,
We did have a Gideon violation. And I thought you'd go ahead and with that
That's what the record indicates. There's no attorney.
I thought one of your briefs, I think, says the burden is on the government.
Yes, sir.
Prove that he did have a lawyer.
Yes.
You know, but one of the additional points that concerned me was that you went so far, Fowler went so far, he not only didn't object, but he withdrew his objections to the PSR at sentencing. He affirmatively withdrew
Yes,
the
sir.
objections to the PSR, and the debate that we might be having about the South Carolina Justice Department data. This is not a debate about the prior conviction that we should be having up here. It's a debate that should be taking place before the trial judge, with the adversary system functioning in the way that the adversary system is expected to. This is the worst place to be doing this kind of ab initio sentencing investigations. This just isn't a forum for this kind of debate. And it's not your fault at all, but the problem was, as we've said, that there was no objection. And you're familiar with that Terry case, aren't you?
Sure.
What is your take on, what's your response on the notion that the defendant waived any objection to the PSR? Because it seems to me you're making an objection to the PSR now, and yet any objection that the defendant might have had was withdrawn. And the question is, should we construe that as a waiver?
It is absolutely correct, Your Honor, that the lawyer waived his objections, and that was done in open court. The only indication that he was objecting to the 1 point addition was in a sentencing memorandum, where he basically said, I can't figure out what to do. But it was waived, and as a result, the judge relied on the PSR. My point today, that I'm not making very well, but I'm trying, is that when the probation office relied on unreliable, if they did, relied on unreliable records, then the court made a plain error.
What would happen if that was pointed out, an objection was made and said, there's a point being assessed here without sufficient information?
Yes, sir, absolutely.
Immediately, the probation office would have run that down, or the U.S. attorney, and the court would have said, okay, I need evidence on this before I prove it.
Yes, sir.
But in this case, it's on there. The 1 point is added. That some objections are made. The attorney withdraws the objections, and basically the court, there's no objection to the pre-sentence report is written, and the court adopts it and points one. Now on appeal, we say that objection should not have been waived, number one. And number two, that objection is there because there was insufficient information. So now on appeal, the U.S. attorney comes in and says, well, I do have information. I could have gotten it then. And as you know, what it shows, the document shows.
Yes, sir.
Now, so your argument now is the document's still insufficient, and asking us, an appellate court, to start making rulings of fact and rulings about evidence.
Just to make one comment, Your Honor, I think that document was available to probation. Wasn't just
Well, sure, but yeah,
and I'm assuming that they probably looked at it.
and if they looked at it, then it's
why I had
even better
objected.
for the probation, because they assessed a point, and they concluded the document shows that there was a trial, number one, finding of guilt, number two.
It's correct, Your Honor. Otherwise, they wouldn't have added the point.
Yeah.
I understand, and I
But
wish that I could.
my pressing my questions like this to you is like Judge Wilkinson said, it's we have brought you in, face the music here, and
And it's been a
and
treat.
we appreciate that.
This is good
I was in the
experience.
Army, and I had sergeant majors train me to be available.
This way the adversary system works.
Yes, sir.
And by the rules, I mean, and this doesn't work out for your fellow, then he has to go 2255 or something and say the waiver down below was ineffective counsel.
I understand.
That's not before us. You're playing the cards that you were dealt, and it wasn't a very good hand.
Well, I've had that happen a lot as a defense attorney, Your Honor.
But you don't need to fold.
I'm not.
No,
I still am arguing plain error.
You don't fold on us. That's right.
Still arguing plain error.
All right, thank you very much, counsel.
Thank you.
Mr. DeHall.
Thank you, Your Honors. May it please the court. The district court reasonably imposed a sentence at the bottom of Mr. Fowler's guideline range. In so doing, it made no error, let alone plain error, in calculating his criminal history score, and it also adequately explained the sentence that it was imposing. We therefore submit that the sentence should be affirmed. Now, courts raised two issues. I'll go in order the way they've been raised, unless the court would like to go otherwise. But on this criminal history point, we certainly believe that under cases like Vincent, Weston, Foster, those cases all indicate that, as Your Honors have pointed out, that burden of proving some sort of a Gideon violation would be on the defendant because of the presumption of regularity that attaches to a final conviction. I believe in.
Did the fellow have a lawyer at that trial?
Well, PSR says we don't know one way or another. That's absolutely true. I would quote Vincent in saying that that ambiguity, and that Vincent involved that exact same type of language in the PSR, says that would not establish a plain error in counting that conviction. So it's not an affirmative statement that there was a potential Gideon violation. It is just an acknowledgement that information was lacking because the probation officer was not able to find this. It's not like in the Hondo case, which was another South Carolina case, where probation affirmatively stated that there was a lack of counsel. They were able to determine that in the Hondo case. Here, as is the practice with this probation office, if they just don't know, they just say it's unknown. And at that point, the presumption of regularity from Park, the South Carolina statute requiring that every defendant be either afforded counsel or advised to it, or that they waive, those things come into play. And so we would say, given that presumption, given the absence of the presentation below, there was no error in the district court relying on the PSR, that any burden the government had in proving the fact of that conviction or attorney representation.
You're saying there's a presumption of regularity.
Yes, sir.
That applies.
Yes, Your Honor.
Is that a federal court rule or state of South Carolina rule that you're arguing about?
It's a bit of a combination. So when we go to Park, that attaches a burden on the defendant of rebutting a presumption of regularity. And this court, in cases like I believe it's Weston and Foster, have looked at that statute, the South Carolina statute, and said we will presume that that is being applied in every case. So it kind of works in tandem. So when you have that here, we have a presumption that a defendant like Mr. Fowler was advised of his right to have an attorney, and if he didn't have one in that CDV case, it was because he waived it. Yes, Judge Williams.
Do you have anything further to add?
On that point, I would just say I understand counsel's criticisms of the public index that we've attached. We think that this is a reliable system that the South Carolina Judicial Department provides, and indeed, Mr. Fowler in his sentencing memorandum below attached two other printouts from that same system as a way of proving facts about some of his other convictions. So we think.
Well, it may be the reason that the PSR, that there were no objections to the PSR, was that Fowler, that the lawyer felt that any objection would be futile in light of the data sheet from the South Carolina Justice Department, And the fact that you can look beyond Shepherd documents if you need to, just to determine the fact of a conviction. But it may be that the reason that there was no objection was because the lawyer felt quite correctly that there was no basis for an objection, that it was perfectly accurate, that he had had a conviction, a sentence of participation in a domestic violence program, and that should count. I mean, we're assuming that the objection would have revealed some mistake, but it doesn't appear to me on the face of it that there was a mistake. We're talking about a sentence upon a guilty plea, and why wouldn't a sentence of participation in a CDV, a criminal domestic violence program, why wouldn't that count? I mean, why wouldn't you add a criminal history point? And the lawyer probably looked at that and said, yeah, I haven't got much of an argument here. And that may have led to the waiver.
I think that's a perfectly reasonable way of looking through this. I mean, as Mr. Watkins pointed out, in one of the sentencing memoranda, they say, well, we don't have a lot of information on this, so we can't really challenge it. But we also know, because they said it at the beginning of the hearing, that Mr. Fowler and Mr. Yarborough, counsel below, they went through this PSR together. So clearly they had it in mind. Well, maybe is there any basis for challenging it? But they discussed it. So if Mr. Fowler thought, well, no, I actually wasn't convicted, even though the PSR says I was, or no, maybe I didn't have an attorney and I was denied it, you would think that at some point in that conversation they might have pursued it if there was anything there to pursue. But your point, Judge Wilkinson, is well taken about the fact that we're now sort of litigating this point for the first time in the Court of Appeals, and really that's not the correct forum for this. But we have to just rely on what record is here, and what the record we have is indicating only that this was a properly secured conviction and a sentence that followed from it, and therefore the assessment of 1 point was proper under 4A 1.1c.
All right. Do you have anything further that you wish to add, sir?
On that point, no, Your Honor. I'm happy to go into the second issue about the adequacy of the explanation if the court has any questions about that.
Well, let's see if the court has some questions about you're talking about the argument for a downward departure.
That's correct, Your Honor.
Well, let's see if the court has some questions about that. Judge Niemeyer, do you have some questions any questions about the
Good questions.
Judge King, do you have any questions about addressing the arguments for a downward departure?
I do not.
All right, we thank you.
I'm back.
We're glad to see you back.
Thank you, sir. I would like to make just a couple of quick points. On the first thing on the record is that I don't think the record is adequate. Obviously, I think I'm going to be outvoted on that.
Well, just on that, I hear what you're saying, and you bring long experience and suggest that such a document that we have before us could be just a pro forma response to going into that counseling system, that they somebody, you come into court, the guy's there alone, we'll go into the counseling session, and that's what they fill in. But the problem with that is we don't have anything to support that. And if in order to find some error, I would think we would need to have a proffer of what would be shown if a fuller development of the record was made. And we don't. I mean, we still see two things. We see, number one, there was a trial, and two, there was a finding of guilt. And we don't have any evidence about lawyering, but we also don't know whether he waived the lawyer or there was a lawyer. And you point out, I really understand what you're saying about state court proceedings. You know, I was sort of in your same boat too for a long time. And, but it's hard for us to just have this dialogue and say, well, maybe that could have happened, and therefore we set it aside, even though no discussion of this was conducted in the district court. We're here to correct error, and I guess your argument is the error is the insufficiency of evidence.
My argument, I guess, and quickly, is that I think it was plain error, and I agree with you. Burden then shifted to the attorney, and it makes me feel warm about the amount of objections that I often make to do a record. That's the point I wanted to make. Would you like for me to comment on the judge's sentencing justifications?
Well, it's your argument. You could, we didn't have any
understand.
further questions, but you may make any point here.
I think I'm fine on that. Thank you.
We thank you and we appreciate both of your arguments. And we'll proceed directly into our second case.
We would normally come down and shake hands with you. Judge Wilkinson is remote, but we would be able to, but as you know,
Pleased to hear from you.
Thank you, Your Honor. May it please the court, my name is Kimberly Albro, and I'm here on behalf of the appellant Jason Dix. Mr. Dix raised 3 points related to his issue in briefing. First, his position is that notice was lacking for the 4-level enhancement, that his gun possession was in connection with failure to stop for a blue light. Second, he submits that the gun in no way was possessed in connection with failure to stop for a blue light in the legal definition, and the gun did not facilitate failure to stop. And finally, even if the gun could be connected to a failure to stop for a blue light offense, there were no reasons given by the government or the district court in this case. I will first talk about the notice issue. In the PSR, the one crime was identified, and that was a grand larceny related to an alleged stolen car. Mr. Dix objected to that. The government was on notice that he would be objecting to that at his sentencing hearing. And at the sentencing hearing, when it appeared the district court would agree with Mr. Dix, the government shifted positions and said, well, there's this failure to stop for a blue light. It's called a misdemeanor in South Carolina, but it gets up to 3 years in prison. So we would rely on that as an alternative. So while it was raised at sentencing, unlike the notice he received in the PSR that the stolen car would be assessed, he did not have a chance to look for some evidence, find a witness, whatever, to argue about the failure to stop for a blue light.
let me ask you, is there any suggestion that evidence would show that he did not stop for a blue light. That was discussed entirely. It was in the pre-sentence report and it was in the discussion. The only aspect of it that was not discussed is that the government didn't rely on the blue light, but on the stolen car. And but when the district court decided to rely on the blue light, counsel, I don't know if it's you, but counsel said this is the first time I've heard that. But then there was a discussion and there was an argument. But I don't think there was any argument as to whether he violated the blue light, and there's no suggestion he didn't violate the blue light law. The discussion was a little bit about, there was a little discussion about whether it's a felony, whether it qualified. But the alternative is if the attorney really felt like he had more to present, he certainly could have said, I'd like to have a suspension for a day or so on the sentencing and let me go check this out. But he went and made his arguments and the court considered them. And but the real question is, there really was no objection to the conduct as reported in the PSR and as related by counsel. He did violate the blue light. And the only question is whether it was now going to be used in the calculation. And he made whatever argument he could, which was basically it's a misdemeanor. And of course, as a matter of law, we know that the qualification of an offense for a felony is defined by federal law, and it involves a year, it's exceeding a year.
Well, Judge Niemeyer, I agree with almost everything you said. I disagree. I don't think his basis for argument was that it was a misdemeanor, because we have this issue all the time in South Carolina. There are a lot of crimes called misdemeanors, but they get more than a year.
Well, I don't know if there was a real argument about it, but there was a question thought, I remember, whereas what was the available penalty?
Right. I think that discussion actually was between the district court and the government, but we don't have an objection to that, and that's not an issue here. And I think the point is that, and I tried to make this point in the briefing, it's not about whether he failed to stop for a blue light. He absolutely failed to stop for a blue light, and he admitted that from the beginning. The question was whether, when he prepared for his sentencing hearing and he prepared to make an argument against one crime, and then at the last minute, kind of like in the Hodge case, the position was changed.
Well, it was changed, and it was changed late in the game. It was changed at sentencing, but he did have a notice before the sentence was imposed. And so now the question is, what is the objection to using it? Let's say it was given to you 3 weeks before. What would the objection to using the blue light law?
Well, I'm not sure what it is, and I think counsel did the best he could at the trial court. And the point about the notice aspect, which I would agree is a closer call than perhaps in the Hodge case.
But the Hodge case was no notice. Hodge case was raised for the first time in collateral review.
Correct.
But
Correct.
My point on this one is the whole issue is a notice issue. And my question is, if the notice was inadequate, then it seems to me the only way we can measure whether it was inadequate is whether there is some development that could have been undertaken that wasn't. But we know the crime was committed. He admitted committing the crime. The court says, I'm going to use the blue light offense. And you say, well, he didn't have a chance to prepare. My question is, what further could be said on that regard?
Well, I think I put everything in the briefing that I could think of to support the fact, like I said, the second issue is kind of moving into the second issue.
Well, let me just stick with this for a second, because you raised a Hodge issue. And I gather at this point, you have nothing to proffer as to what further could have been investigated or prepared with respect to the use of blue light law.
Well, I think there was a woman who was let out of the car at some point. And he said it was a hitchhiker, but I don't know. Counsel could have looked into that to see if she was available to say what was going on in the car, if the car was visible, if he tried to use the gun or not.
He admitted to not stopping in response to the blue light.
Correct, but there's still, it still has to be.
Not only that, he fled and admitted to facts that he drove over 100 miles an hour and then ultimately crashed the car.
Well, correct. I mean, there's no
the violation is not at issue, is it?
The violation of the blue light, like I said, he admitted that he failed to stop for a blue light. So that moves into the question of if the court determines there's adequate notice, which it sounds like that's the way the court's leaning, that there was adequate
I'm not
notice.
leaning, I'm trying to probe how deep your argument is. You said you basically have a Hodge violation because you didn't have notice. And I'm suggesting you got pre-sentencing notice. It was late.
Y'all talk about Hodge, but we had a case since then called Benton. Are you familiar with that one?
I don't think so.
You're not?
I don't think so. I don't think we cited that. But they're in my reply brief, I did
Well,
point
it's
to this.
right on point on this thing. They need to give notice what they're relying on in the PSR. It's 4th Circuit case. Harris wrote it. I was on the panel.
Was it Blount?
Pardon?
Blount?
Benton.
Okay. I'm familiar with Blount, which is along.
January 24th, 2022. 24 Feds 4th 309. But it was a collateral proceeding. Okay.
This
And
is,
the government argued there that Hodge was bad law. As I remember, they were arguing about that Hodge was bad law. We couldn't apply, but and Benton was decided, and I think the government had to distinguish Benton. Or the issue about their notice thing, and I'll say this: Hodge and Benton both are collateral attacks, and this is a direct appeal.
correct. And in my reply brief, that's where I addressed the case.
This is a direct appeal, but it's after all of your briefing in this case,
Okay.
and neither of you have filed any 28J letter. It's as if we took Benton out and threw it down the elevator shaft. But neither of you thought it had anything to do with it.
No, I mean, it's an oversight on my part if I missed a case that I should have filed a 28J letter on. But again, I found some authority on direct review that appeared to rely on Hodge, and I cited that in my reply brief. So back to Judge Niemeyer's question about what
But
kind
your reply brief was filed before Benton came out.
Right. So his argument after the notice issue is that it doesn't apply anyway, because this gun was never shown to facilitate the failure to stop for a blue light. The South Carolina Code blue light statute is 56-5.
Here's what Benton said. Just as in Hodge, the apparently intentional exclusion of some convictions left Benton without notice that the government later might use those same convictions to support an ACCA enhancement. And lacking such notice, Benton had no reason at sentencing to argue, and perhaps some good reason not to argue, that the overlooked convictions might qualify as separate predicate offenses.
That sounds
like that
favorable.
what helps your argument. The government may distinguish it and say it, or try to distinguish it on this notice question, but that's what we got to grapple with, I think.
Well, I think Hodge said something similar, which is
It does. It
point
says
of-
it's just as in Hodge. That's
Right.
the predicate of what the Benton decision says.
But that was the point about.
But the U.S. attorney said that Hodge was bad law, I think. But we applied it. That was a collateral attack, so and Hodge was, and this is Benton is too. And this is direct appeal.
Right. And so the Hodge issue about the notice, why it was important for Mr. Dix to get notice, is for the same thing that was written in Hodge, that it's not going to be.
Except in both Hodge and Benton, sentence was imposed without notice of the government's later position. In this case, the notice was given before the sentence was imposed, with the opportunity to object and explain. Or if the counsel didn't have adequate information, he could have requested some more time or postponement or But in this case, there was no mystery about the qualification of the blue light. It was just that the pre-sentence report had not used it, and the judge thought it was better to apply the blue light, even though the pre-sentence judge. And so whatever objection to that the sentence had not been imposed, whatever objection to that was discussed, and it was over several pages in the sentencing hearing.
Well, that is correct, but
Well, that's not completely correct. It wasn't relied on here in the PSR as what they were dependent on.
well, that's correct. And what I was going to
And
say
that's what,
is
that's what Benton discussed.
there is,
Whether it has to be identified in the PSR, but it's in the collateral attack analysis. I mean, that's the case too.
well, and I relied on Rule 32 for the same argument. The fact that it's not in the PSR, there is some case law. It was a Fifth Circuit case, Garcia, that the government relied on. I think I cited it first, but it said that, you know, if the defendant actually knows about the facts that are relied on, that's good enough. And they cite to Rule 32D. But what 32D does is just give the timeline for when the defendant is entitled to get the PSR. And when he does, he has 14 days to make objections. And then the PSR in its final form with what they do in South Carolina is an addendum addressing any objections. The defendant and the court and the parties, all the parties get the PSR 7 days before
Counselor,
sentencing.
let me ask you this. Is it going to be, what would be different if we sent it back and then you had notice that the predicate that the government was, the felony predicate that the government was relying on was the failure to stop for a blue light? And Judge Niemeyer has said, well, what would you say in response to that? So is anything going to be any different if we sent it back on an absence of notice? You have notice, the felony is the predicate felony is recognized as one of a failure to stop for a blue light. The in connection with language is applied, and we're right back to the same place that we started. In other words, I just wonder if we're not just spinning our wheels, because what practical difference does this argument make?
Well, I think that Mr. Dix's rights would be better protected because he'd have the chance to fully prepare to respond to that objection.
All right, well, you've had the chance to fully prepare. I think Judge Niemeyer was asking what would he say, because it's absolutely, you say, well, it's we recognize that this is not a misdemeanor. It's a felony charge. There's no question that he committed the felony. And if it's a felony, and if he committed it, what is there to say?
Well, I mean, my time has run. Would you like me to respond?
All right, well, would you mind addressing it on rebuttal?
That's fine.
Okay. All right, counsel, we'd be delighted to hear from you.
Thank you, Your Honors. Good morning. My name is Lamar Fayal, and I represent the United States of America. May it please the court. Jason Dix, at both his guilty plea and in the PSR, admitted to all the facts necessary for the court to conclude that he had committed the offense of failure to stop for a blue light. Additionally, at his sentencing hearing, him, his counsel, the court, and the government had an entire discussion, argument, and presented legal analysis as to whether or not the guideline enhancement for possession of a firearm in connection with felony offense applied. After hearing the arguments of counsel and considering the guidelines and the law, the court, based on sufficient evidence, found that the guideline did apply. Additionally, the failure to stop for blue light charge that the court used to assess that guideline was the offense committed when Mr. Dix engaged in the offense leading to his indictment, and he was arrested by local law enforcement for that offense. All those things taken together show that Mr. Dix had proper notice that this guideline could have applied. He had a chance to argue in court, and the facts and evidence put forth before the court were sufficient for the court to determine that he possessed the
And the one
firearm.
relied on the PSR,
Yes, Your-
right? It was not relied on the PSR, that blue light.
No, Your Honor,
It was not relied on the PSR. How do you get around the Benton case? Are you familiar with the Benton case?
my understanding of the Benton case, Your Honor, is that it was a lateral.
It was a
appeal.
collateral attack proceeding.
Yes,
It
and whether,
was. But
whether or not-
is it your position that it doesn't apply on direct appeal? That is there a material distinction that you can make to say that it doesn't apply in a direct appeal situation?
yes, Your Honor,
The
well,
legal principles.
yes, Your Honor, and specifically as it applied to Hodge, Hodge specific defendant must be able to confront the issues that may affect their exposure or criminal sentencing at the time of sentencing. And Mr. Dix was able to do that here. It was later than
No,
usual.
but Benton doesn't apply on direct appeal.
I do not think so, Your Honor. Those are cases.
Well,
where
it's
the-
not the question of on direct appeal. It's a question whether it's before or after sentencing. In other words, both Benton and Hodge involved an effort to change the criteria for sentencing post hoc after the sentencing.
Correct, Your Honor.
We decided a case called Rumley. I don't know if you know that. We made that distinction. And we noted that if the change is made before sentencing, Hodge doesn't apply. And Hodge was a collateral, came after the sentence had been imposed. But here, the change was made before sentencing. And there's nothing magical about binding about the PSR if the court is changing the PSR. The court can look at the PSR and reject any part of it or make and I think the big issue that's legitimate is which Hodge relied on and Bennett is notice. You have to have notice of this before the sentence is imposed. And in this case, the notice was late. And so that, to me, that's a pretty serious problem to give notice late. I think the judge had the authority to go and change the pre-sentence report or whatever. The question, I think, is whether the defendant had the opportunity to respond and prepare for that.
That's correct, Your Honor. And I agree with the distinction Your Honor is making as it relates to Hodge. But here, because Hodge was after the sentencing, the government became aware that a certain predicate might not apply and tried to apply other predicates. In this case, before sentencing, unlike Hodge, unlike Benton, the government presented facts sufficient to support the enhancement, and the defendant had a chance to challenge those facts. Those facts were late in the ordinary course of things, but if you look at the record, there's no disputing the facts here. Mr. Dix clearly failed to stop for a blue light. He had a firearm on the floorboard of his car when he did so. He was on probation, and the court determined that the fact that he was on probation.
How do you know that he had an opportunity to dispute? He wasn't disputing the fact that he had committed the felony, correct?
Correct, Your Honor. He was not disputing that at all, and quite frankly,
well,
evidence there wasn't much to dispute.
What would he have been disputing?
The only thing Mr. Dix was disputing in this case is whether or not the enhancement essentially applied. He was essentially making. He agreed to the facts, so he was trying to make an argument that based on the facts before the court, that wasn't in connection with possession of a firearm.
But in the real question is here, it may be less one of notice than the question of whether this was in connection with another felony offense. Now, was that question argued, the in connection point?
Yes, Your Honor, it was argued, and the court made specific factual findings to determine that it was in connection with. The court adopted the facts in the pre-sentence report that Mr. Dix was traveling over 100 miles per hour, did a U-turn in a cul-de-sac, almost hit a mailbox, almost hit a law enforcement officer, hit another vehicle, and both him and the other occupant went to the hospital.
But isn't that the real question in this case as to whether the in connection with link is satisfied?
Correct, Your Honor. And this court's language says that in connection with means it had some purpose or effect on the crime, and it was not accidental or by coincidence. In this case,
and your argument is that's a factual matter, or at least a matter for the district court to apply, and that some deference is due to them and due to the district court. And when you have a firearm tagged with the enhanced penalties that went along with possession of a firearm by a convicted felon. I mean, isn't that the real issue as to whether the application of those words in connection with was valid, huh?
I agree with that, Your Honor, and in this case, it was. And the court, there's sufficient facts on the record to support not only that he committed the offense of failure to stop for blue light.
I mean, you've got somebody speeding over 100 miles an hour, which I don't know what the speed limit in that zone was, but it wouldn't have approached 100 miles an hour. And the question then becomes, well, why was he doing it? And the district court seemed to me perfectly within its rights to say the whole reason he was doing it was because he, as many, many others knew, of the enhanced penalties that go along with the felon in possession. And he was going to do his darndest to avoid those enhanced penalties. And in the spur of the moment, he decided the best thing to do is to go at this highly excessive rate of speed. I just thought that was really what the case was about, as to whether the district court's discretion to apply that in connection with another felony offense to what was done. It seems to me this is what the 2K 2.1B 6B, there's so many letters and numbers here, I can't get through it all. But that's the heart of this, isn't it?
Yes, Your Honor. I would note one additional thing the court found was that Mr. Dix was on probation when he committed the offense of failure to stop for a blue light. And because he was on probation, he was not allowed to carry a firearm. And the court stated that that was an additional motivating factor for him to flee from law enforcement while he had the firearm on his.
Now, did the defendant have an adequate opportunity and an adequate notice to argue his side of the in connection with application? Did he have an adequate chance to make that argument?
Yes, Your Honor. During the sentencing phase, the defendant's attorney made several assertions that there's no reasonable way that you could say that a firearm can be connected with failure to stop for a blue light. He was running from police, but the firearm was a separate and distinct offense from that. The court disagreed with his attorney's assertions, and his attorney made a pretty full and complete argument. And I think the reason his attorney did that and did not ask for more time that was suggested earlier, because the facts were not in dispute, Your Honor. He agreed to the facts in the PSR. He agreed to the similar facts when he pled guilty. The issue before the court was really whether or not this enhancement applied. And this court said that there was sufficient evidence to say that it did.
So the question I'm coming back to is, we look at notice on two levels, and this is prior to the sentence. He had noticed that the blue light was going to be the predicate, and he had noticed that the district court was going to apply the in connection with language, and he had the chance to argue that this was an invalid predicate, and he had the chance to argue that the in connection with language was wrongfully applied. So if he had the chance to argue both of those things, hasn't the overall objective of fairness in sentencing been achieved? That's the question I ask myself.
I agree, Your Honor, and the Hodge standard and the Benton standard all stand for the proposition that the deadline, if you will, for these things to be brought up is prior to sentencing. The defendant has a chance prior to sentencing to address these issues, have a
The
full.
PSR didn't identify the blue light as a predicate.
It did not identify.
It did not.
It
Did not.
It,
That's the thing. It did not. The PSR did not.
that's correct, Your Honor. It did not
And
identify.
notwithstanding that, you're saying there's notice and that you can sustain that thing in this circuit in the face of Hodge and Benton.
Yes, Your Honor. Hodge and
Okay.
Benton were cases
Where
where
it was not identified in the PSR. And those cases say it needs to be.
Hodge and Benton were cases where it was not identified.
It was talked about, it was discussed, it was argued about, but the PSR didn't rely on it.
Correct. Specifically, Hodge and Benton, the court did not specifically use the prior convictions that the government was trying to assert in determining that those applied to the ACC predicates at sentencing. And subsequent to sentencing, without the defendant having an effective chance to argue those points and present those arguments before the court, then the government came back and said, well, we want to uphold the sentencing because of these additional convictions that the defendant did not have a chance to confront, explain, dispute at sentencing. I think that's a distinguishing factor with Hodge and Benton. In this case, is exactly the opposite. The defendant had a fulsome discussion with the court, was allowed to confront the evidence, the guidelines, the legal analysis in the court after hearing from the defendant about that issue, unlike in Hodge, unlike in Benton, was able to determine based on the facts of the law that the guideline did indeed apply. And I think that's what distinguishes it. The court's precedents assert that the time for these things to be handled is prior to the defendant receiving his sentencing and for the court to be able to
Well, now, one question with regard to this, counsel. Again, for the fairness, where something is not in the PSR, did the defendant would have had the opportunity to ask for a continuance. And the defendant would say, I'm sorry, I'm caught off guard by this. I need additional time to develop my arguments and facts, et cetera, and use the fact that it wasn't in the PSR as the basis for a motion for continuance, which would seem to me to be a perfectly fair motion to make. But was there any request for an extension of time?
There was not in this case, Your Honor, and that was available to the defense.
And the government could have moved for an extension of time and gotten to try to get it fixed, couldn't they?
The government is also allowed to move for an extension of time.
They could have. They could have, but the district court imposed a 4-level sentencing enhancement based upon a felony not identified in the PSR.
That's correct, Your Honor.
Period.
Sorry, Your Honor.
Yes.
Yeah.
I mean, I'm just making that statement.
That is correct.
I guess I shouldn't say saying period. I should have put a question mark.
That is
Maybe the question anyway for you.
Yes, Your Honor. That is correct, Your Honor. And the court could have done that with or without the government raising that issue. And I think I've sufficiently covered notice and the sufficiency of the evidence. I think the evidence here is not in dispute. I think the court made a clear factual finding based on sufficient facts of the record that were not clearly erroneous.
All right, now what can we do? What can we do going forward to make sure? Because Judge King certainly raises a valid point. What can we do to make sure that the government turns square corners on this and in the future puts down these, puts the predicates and the felony offenses that it's going to rely on in the PSR? I mean, because what you don't want is a situation where they can get sloppy about putting the offenses in the PSR and just say, oh, we'll come around to it. We'll come around to it later. I mean, how can we assure ourselves? I mean, reversing this would be one thing, but it seems to me that I don't know what would be different on remand Oftentimes we give warnings in opinions while stopping short of an outright reversal. But what can we do to make sure that the government doesn't go sloppy on us?
I think the best practice here, Your Honor, if there's any sort of warnings to be given to the government, is the notion that PSRs, government should not only object to information in the PSR that it disagrees with, which we normally consider colloquially when it comes to objections, but if the government feels that there's more information that should be included in the PSR, that they should do that too. That wouldn't necessarily be an objection. I guess more of I guess you can call it an objection, but in this case, there's less of an issue because Mr. Dix was actually arrested for the crime of failure to stop a blue light by local law enforcement when he was in possession of the firearm. But if
we remanded this case, is the result likely to be any different at all, or is it just we're going to arrive at the very same place? Is this just a hoop jump, or is there a chance in your view that there would be a different outcome in terms of the application of the 2K 2.1 enhancement? What's your thought about that?
With the facts of this case that were stipulated to by the defendant at his guilty plea and in the guidelines and at sentencing, and here before this court today, I don't think the application of the guideline would be any different on remand. The facts are very clear in this case, and the court made a reasonable.
Your argument is wouldn't have made any difference. I used to be a assistant U.S. attorney and a U.S. attorney, and I was a defense lawyer all the time too, in several cases. But I can remember when I was the prosecutor, the defense lawyers, and maybe the judges, from time to time, sort of comment to me that we relying too much on the clearly guilty rule. That was the fallback position the government would take, according to sometimes I'll say the defense lawyers or maybe even the court. They're falling back to the clearly guilty rule. It would come out the same way. He was clearly guilty. That seems to be sort of what I'm hearing from you. The bottom line is it's a clearly guilty rule. The district court imposed a 4-level sentencing enhancement based on a felony not identified in the PSR. Period or question mark. But he was clearly guilty anyway, all of it. And there were other felonies, and everything's all right.
I'm only using, to the extent that the clearly guilty rule applies in this case, Your Honor, he's only clearly guilty of failure to stop for a blue light because the evidence showed that he's clearly guilty, and he admitted to those facts at his guilty plea and in the PSR, and those facts are not very well in dispute by any party, the defense, the prosecution, or the court. So in this case, I would say that he is clearly guilty. The issue in this case is whether or not the guideline applied. That was really what the court was determining. And in this case, based on the facts in the record, the court made the right determination, and the court, based on this court's precedent, could have made that determination outside of the government's argument. With that, I see that I'm out of time, and unless there are any more questions, we would rest on our briefs.
We thank you very much, counsel.
Thank you.
And now we'd like to hear from the appellant in rebuttal.
Thank you, Your Honor. Mr. Dix would obviously disagree that the outcome would not be different if it was remanded. And that was the question that I was left with on my opening. And I would say pages 12 through 15 of the brief and 6 through 8 of the reply brief cite to extensive law, making the argument about why the in connection portion was not proved. I mean, the only thing the government even put in their brief about that was he was much more likely to fail to stop for a blue light because he had a gun in the car, but no connection was made. That's just speculation. And that would be what would be considered on remand, is whether or not that part of the requirement, whether the gun facilitated it, whether that was met at all, because failure to stop for a blue light in South Carolina, all that's required.
Did you argue that very thing before Judge Child?
Well, the council did the best he could when the course changed and all of a sudden it was another felony. He did do the best that he could, but he couldn't cite any of this law because he didn't have it available.
Did you ask for additional time or continuance?
No, I don't disagree. He did not ask for additional time. But I would say that what was overlooked is in Rule 32 is that actual knowledge isn't enough in what's cited in Rule 32D. 32I allows late objections, but it has to be with good cause. And none of that was ever shown why there was good cause for not saying that all of the state charges arising from this particular conduct couldn't have been used for the enhancement.
All right, so if we were to remand, you would concede that the whole question of the application of the 2K 2.1 enhancement was still, we wouldn't be saying that there was any kind of error, and that the application of the enhancement might still very well be proper. Is that correct?
Well, if it was remanded and a new PSR was issued with the basis for the 4-level enhancement identified, Mr. Dix would have a full opportunity to argue at sentencing why it didn't apply. I mean, even the district court's findings in here, which I would disagree with the government, they tried to couch it as a factual argument. I say it's a legal argument because in connection with means facilitate. It can't just be by coincidence or accident. And I think Mr. Dix has a good argument that the gun was just in the car and his failure to stop for a blue light was complete when he didn't stop for the police. And other reasons.
Did you make that argument earlier before the district court? You would have to, that would be your argument.
The government
enhancement.
When the government raised the issue about this additional felony, like I said, counsel did the best he could. Switching gears, using the argument he had prepared related to the stolen gun.
Counsel, please.
I'm sorry.
I said maybe because of the audio transmission, you couldn't understand me, and that's perfectly understandable. But you would have made what you just said. You would have made that argument before the district court, would you not? That was your best argument.
About in connection with
the fact that the firearm was on the floorboard was just incidental, and that it didn't really factor into his speeding.
Right. I believe the argument was more general terms. Like I said, the citations in the brief, obviously I had the benefit of being able to research it, make the argument about why it wasn't in connection. And I would say even the district court's holdings, what they said was that him having the gun, knowing he was on probation, is why he didn't stop for the blue light. But that's not the same as how it facilitated failure to stop for a blue light, because in South Carolina, failure to stop for a blue light, even if you don't hear the sirens or see the blue light, you can be held accountable for that offense. So it was never made clear by the government. Like I said, even in the briefing, all that was said was, well, he's just as likely, he would have stopped if he didn't have the gun in the car. Well, he was still on probation.
That makes some sense.
He was on drugs.
I mean, if you want to assume, why was he running? Why wouldn't he stop? Well, he had a gun in the car. He didn't want to be caught with the gun in the car.
Right, but that and that's not the same as the gun facilitated his failure.
I understand that, but
yeah,
but the fact he didn't stop, it made some sense that perhaps he didn't stop for that reason.
But he also noted at sentencing that he has a long-standing drug problem, and he was high at the time he was driving, and he was on probation and thought he had probation warrants. So there are a lot of reasons he wouldn't stop, but that doesn't mean that any of those reasons, that the gun facilitated it in the way it's described legally. Like, did it made it easier for him not to stop because he had the gun in the car? And I did cite in the reply brief, and I apologize, I'm over time. So there's an 11th Circuit case in the reply brief that gives a more thorough connection to those two things. Thank you, Your Honors.
We thank you, and we will look forward to hearing from the attorneys in our last case.
Glenn Hara. I represent Career Counseling, Inc. The district court abused its discretion in denying class certification in this case because its ruling was based on several erroneous legal conclusions. The chief erroneous legal conclusion, and the one I think we should address first, is the proposition that the district court was required to follow the interpretation of the Consumer and Governmental Affairs Bureau of the FCC in the AmeriFactors Bureau ruling. This conclusion was the core of the district court's denial of class certification. Everything follows from it, and it's fatally flawed.
You say that, and I'll come back to this, but my concern is, let's assume you're right. My next question would be, did the district court get it wrong? Because the statute on its face can be addressed to define a telephone facsimile machine, and distinguishes that from a computer. And so it seems to me we would, if we went to the statute directly without going through the FCC opinion, the question is, could we get to the same place, or would we get to the same place? I'm not trying to discourage you from arguing the role of the agency opinion, which I think is a very complex question. But I'm wondering whether we as a court, just as a matter of law, wouldn't just look at the statute first before we get into any of that and decide whether we need that opinion or whether it persuades us on anything. Because our role is to interpret the scope of the class in this case with respect to the requirements of the actual act. But go ahead. I'll be asking you about that later. You can devote your attention to that opinion too, if you want.
Judge Niemeyer, I agree with that proposal completely. There's one circuit court of appeals that has addressed that very question that you just raised, Your Honor. It's the Sixth Circuit Court of Appeals in Lingas versus Curidan AG. We discussed it extensively in our briefs because it approached the question in exactly the same way. It said, first, we're going to look at the plain language of the statute. They looked at the definition of telephone facsimile machine in section 227B(a)(3), and it said, this is a very broad definition. It is not limited to traditional standalone fax machines. Congress deliberately wrote it to be broader than that, to cover any equipment that has the capacity to receive text or images over a regular telephone line and the capacity to print onto paper. And that covers much more than just a traditional standalone fax machine.
Except in the actual prohibition in the statute, it makes a distinction between a computer and a fax machine. And you have to remember, this statute was written in 1999 when everybody knew what a fax machine. It's plugged into the telephone, independent telephone, and receives an electronic signal and prints it out on paper. Now we have all kinds of consolidations. We have printers that function as copiers, fax machines, printers, all 3 in 1, and we have computers that are hooked up and connected to them and all Wi-Fi or plugged in. But the statute, when it makes the prohibition, it says that you can't use a fax machine, a computer, or other device to send a telephone fax machine an unsolicited advertisement. So it makes a distinction between a telephone fax machine and a computer and other devices. And the question is, what did Congress have in mind in 1999 when it distinguished between a fax machine and a computer?
I understand, Your Honor.
Yeah, but go ahead with your argument. I didn't want to derail you. I wanted to point out that it seemed to me whatever use you think is appropriate of that FCC opinion, it doesn't mean that all our analysis has to be channeled through that or not. And if it's not channeled through that, that automatically determines the appeal. What we would then conclude, if you're right, is that the district court got it wrong in giving so much reliance on the opinion. But we would still be able to look at the statute.
Absolutely.
Yeah, okay.
And I'm going to move on to the Hobbs Act issue, but I will point out the Sixth Circuit addressed that distinction.
I understand. But it's we're all looking at the same statute.
Right. And it does not say that a computer can't have the relevant capacity.
Well, Congress made a distinction between the computer and a fax machine in its language. And so, and I don't know, if you remember back in 1999, that's before iPhones, but I do remember fax machines, and everybody plugged them in their telephones, and sometimes you had a second line, whatever. And that's the only thing Congress could have had in mind back then.
Your Honor, but even back then, there were other devices that were used to receive faxes other than a traditional standalone fax machine. There were fax modem boards that were addressed in the FCC's 1995 final order. That's a commission order from 1995. From 1995, the 2003 commission order explicitly considered computerized fax
We're
servers.
talking about the statute. We're talking about congressional intent.
I understand, and the FCC is talking about the statute because it reasoned that Congress couldn't have meant to allow easy circumvention of the statute simply because technologies evolve over time. Congress deliberately drafted the definition of telephone facsimile machine to be broad, to focus on the capacity of the equipment, not on what the thing looks
But
like.
reading it broad, as you would suggest, would make every single advertisement that comes over your computer be a violation of this act.
No.
Because it's capable of being printed on paper.
No.
And well, exactly, I looked at how you want to define it. A computer connected to a printer is a fax machine under your argument.
No, I disagree with that because it doesn't have the capacity to receive text or images over a regular telephone line. Fax
Sure,
servers.
can't computers still be plugged into telephone lines?
Sure, and if they're being used in that way, yes, then
No,
it does have the
they don't have to be used in that way. That could be the source of their data. It's pretty slow, and I don't know if many computers do rely on that today, but computers have relied on telephone lines for their data.
Sure, and if you're using it to receive faxes, I agree that is
Not
covered.
faxes, anything online. In other words, you have emails, you have whatever comes in online on your computer would be violating the act. And clearly that isn't where, I mean, today I get 100 advertisements a day on my computer and you just don't pay attention to it. But under your argument, reading it broadly as you would want us to do, that would be a fax machine because it's capable of being reduced to paper. But that, I think that's clearly not what, when you read the act and the court makes a distinction between computers and telephone fax machines. They meant something back then and nobody's, I mean, you're not addressing that in your opinion, but why don't you stick with your argument, the order of your argument? I didn't mean to derail you.
Very well, Your Honor. Well, the notion that a district court is required to follow an interpretation issued by the Consumer and Governmental Affairs Bureau of the FCC, that's a deeply troubling proposition, and this court should not allow that to stand. If it does anything else in this case, it should address that and make clear that that.
Let
is
me
not
ask you,
correct.
can we give it Skidmore deference?
If you find it is an interpretive rule under PDR Network 3, the 2020 opinion in the PDR Network line of cases, then the proper thing to do would be to remand to the district court.
I'm not asking you the relief. I'm asking you, could we rely on the opinion as influential or whatever under Skidmore deference if it were a interpretive opinion?
If it's an interpretive rule, then
Yes.
Skidmore deference is the appropriate standard. That's what PDR Network 3 held. But you know, importantly, the court didn't decide whether the rule at issue in PDR Network was subject to Skidmore deference. It remanded to the district court to decide that in the first.
Well, that's one way to go.
I mean, it held that we adhere to the principle that the district court should have the first opportunity to perform the applicable analysis, citing Fusaro versus Kogan, a 2019 decision in this case. So it didn't imply that it was discretionary. It just held that that's the appropriate course of action. But I want to take one step back just to illustrate why that central proposition that the court's required to follow this thing can't be right. The Factors Bureau ruling was issued by a man named Patrick Weber. He was the chief of the the Bureau, I'm just going to call it, in December 2019. I'm sure he's a nice man. I don't know him. I have nothing against him, but he's just an employee of the FCC. He is not elected by the people. He is not even appointed by the president with the advice and consent of the Senate, like the FCC commissioners are. At least there's some kind of democratic accountability. Mr. Weber is just an employee of the FCC. There's no way under our constitutional system that Mr. Weber has the authority to tell an Article 3 district judge how to interpret a federal statute. That can't be right.
Well, that's very persuasive, it seems to me. If we were compelled to follow an agency opinion, it would deny us of our Article 3 authority and responsibilities.
And, you know, the PDR network line of cases where I was counsel for the plaintiff there, I don't want to seem like I'm trying to hide that or anything. But that involved a final order of the FCC. It was indisputably a final order of the full commission.
But even a final order of the FCC may not be binding on a Article 3 court.
Correct. Absolutely. And Justice Kavanaugh and 3 other justices agree with you, and probably more. But, you know, in the PDR Network 2 case, 4 justices filed that concurring opinion agreeing with you completely, saying a district court is never required to follow the FCC's interpretation. You can, you know, you can decide what level of deference to give. Is it Chevron? Is it Skidmore? This court decided on remand that Skidmore deference is the level for interpretive rules.
Suppose we just feel that the opinion, just without any kind of deference, suppose we just feel that the opinion is correct.
Well, correct in the interpretation of the statute. I mean, that's what Judge Niemeyer was asking me about, I think.
Yeah, I mean, the point that it's hard to get over, as Judge Niemeyer pointed out, this was a statute that was written in 1999, and it has a certain antiquated aspect to it. But the argument can be made that it's up to Congress to bring it up to date, and the difficulty that I have is that there does seem to be a distinction in the act, as Judge Niemeyer pointed out, between a computer and a fax. And there also seems to me to be a difference between the rather broad definition of who is a sender and the rather narrow definition of who is a recipient. And in light of that difference, can it really be said that every piece of spam or whatever is that's sent to a computer is a violation of the act, given the difference, the stark difference in the definition between the sender and the recipient? And there really is, those definitions are written in very different ways.
Your Honor, my time has expired. May I answer?
Well, why don't you bring it up in rebuttal? But I'm just telling you what's bothering me.
Yes, Your Honor.
Lori Mazzuchetti for Appellee Defendant, AmeriFactors Financial Group, LLC. May it please the court. I think your honors are exactly correct that looking at the plain language of the statute, which is what the FCC did in the AmeriFactors.
Well, I was asking questions really of being indicating I'm willing to hear arguments both ways on that.
Understood, Your Honor.
And Judge Wilkinson just pointed out that the breadth of the sending devices is distinct from the breadth of the recipient devices. Sending devices can be a fax machine, a computer, or other device, whereas the receiving device can only be a fax machine. And so Congress clearly made a distinction there that doesn't seem to be that difficult to understand in the context of at least 1999, which goes to the heartland of me. I know all the new people know that everything's integrated and to define. I don't know whether voice over on a computer is a telephone. And as you know, we have telephone regulations. We have whole statutes addressing telephones. And we have Zoom. If it goes over a telephone line or it goes over a cable, is a cable the same as a telephone line? And so it's getting very complex, and Congress is going to have to update these things as the technology progresses. But we're confronted with a 1999 statute where Congress was addressing the harm of people sending faxes sending data to fax machines, which automatically printed them out. Now, the definition, it doesn't have automatically, it has capability of printing it out. But that seems to be the target of the statute. That was just an observation, but I want to hear from your colleague, and I guess to the extent that may help you, you might agree, but let me ask you, do you think the district court was wrong in being so tied to the FCC opinion?
No, Your Honor. I think that the district court appropriately applied the Hobbs Act, but I do acknowledge that it is a complicated question. One minor correction, the Telephone Consumer Protection Act.
Let me ask you just back there. Where is the judicial aspect? I mean, all of a sudden we would be transferring judicial decision-making to the executive.
Well, Your
If
Honor.
we were bound by that, I don't understand. It's a pretty aggressive position, isn't it?
Well, Your Honor, under the statutory regime, Congress clearly delegated rulemaking and other authorities to the FCC, including to interpret the statute, to promulgate rules, to enact guidance.
All those rules and policies have to be consistent with the statute.
That is correct, Your Honor. And this ruling is in fact consistent with the
In the final
statute.
analysis, it comes back to the court, whether they're acting consistently with the statute. I mean, there are different degrees of deference. I'm in the same generation as Judge Niemeyer, so you could put me in about the same position like you just said.
Yeah. And I think there's a lot of ways to get to affirmance here. One way is, of course, to agree with Judge Childs that the district court appropriately applied the Hobbs Act and found that the court was bound by the ruling. Another way to get there is to look at the plain language of the statute, which, as Your Honor noted, it is capable of.
That's what I don't understand is why do we need to get into Chevron deference and Skidmore deference, which it seems to me, does may carry some danger of abdication. But why isn't this argument really very straightforward in that the definition of the sender and the definition of the recipient are very different? There are terms included in the definition of the sender that simply aren't included in the definition that are omitted in the definition of the recipient. And that's independent of any deference. It just seems to me that the more straightforward argument is to look at the language of the two critical parties. Every communication is a communication between a sender on the one hand and a recipient on the other. And so the definition of sender and recipient would seem to me to be absolutely crucial into saying what communications violate the statute. And where there are differences in those crucial terms, we have to pay some attention as a matter of text to the difference. Isn't it that the straightforward argument?
That is very straightforward, Your Honor. And where we get to Chevron deference, for example, is if the court were to determine there was some ambiguity of whether internet fax solutions are covered by that definition. Of course, we can look at the plain reading of the statute and understand that Congress could not possibly have contemplated internet fax solutions that did not exist when it enacted the statute, which one minor clarification was in 1991, a little bit earlier than 99. But these types of solutions didn't exist. And this situation reminds me very much of the situation with Facebook versus DeGood, where very similarly, the FCC had opined and interpreted the meaning of an automatic telephone dialing system under the TCPA. And in that instance, went for a very broad reading and said all of these things are captured that Congress couldn't possibly have intended back in 1991. And the Supreme Court in Facebook it was the April 2021 decision said, no, we have to look at the statutory text and congressional intent.
All right, let me ask you this. If we agree with you on the on the interpretation of the statutory text and say, okay, there's this difference between sender and recipient. Does that automatically make a class action less manageable or administratively unfeasible? Or can those things, can the different groups of recipients be untangled in a fairly easy manner?
Well, here the record evidence, which was unrebutted, demonstrated that those two types of recipients couldn't be untangled in an administratively feasible manner. The plaintiffs had sent out 450 subpoenas to various telecommunications providers, including Verizon and Charter, for example, and said, carriers, tell us which of your subscribers, the recipients, were using an online fax service. And they responded, we don't know. 450 subpoenas were sent out, only about half of which were even responded to at all. And the respondents that had the most critical mass of recipients told us, we don't know. And on that basis, Judge Childs found that there is no way to ascertain through an administratively feasible way.
Why wouldn't it be easily ascertainable as to the way in which the recipients received the allegedly offending advertisements?
Well, that's exactly what the plaintiff tried to do, but failed in doing. And we presented an expert which said this cannot be done in an administratively feasible way because there are no records that exist that would say back in 2016, when this fax was sent, whether the receiving end was a standalone fax machine or an email. There is no way to know that.
Well, why couldn't you define the class to include persons who had a freestanding fax machine connected to a telephone line and ask them to opt out or be bound? Now, the problem, I suppose, is when you get a judgment, then you don't know who to give it to.
That's correct, Your Honor. So I think that would be a fail-safe class because now we're building into the class definition, the element of the claim. The element of the claim is you need to show that the fax was received by a telephone fax machine, and now that's in doubt. If you build it into the class definition itself, which is what the plaintiffs tried to do here, and Judge Child said on this record, where it's demonstrated that there's no way to figure out who's in and who's out, this does not satisfy the ascertainability requirement. And to your point, Your Honor, if we were to go to trial, how would we figure out without mini trials, which is exactly what Judge Child said would have to occur to figure out who would be in and who would be out. So whether there is some other case and some other record evidence that could show you can untangle those things, which I quite frankly haven't seen, in every district court that has applied the AmeriFactors order and looked at the record evidence on class certification has said these things cannot be untangled. And whether that's a failure on ascertainability or predominance, the courts have denied class certification. But on this record, the evidence was unrebutted that couldn't be done.
What's a telephone line?
Well, I feel like that's one of those things, I guess we would know it when we see it, right? But I think it is that too is a complicated definition. I mean, here, I think the distinction is receiving something on a computer versus receiving something, on a telephone.
If you receive it on the computer, it would still have to come through a telephone line if we were even to go that way.
Yeah, a lot of things come through a telephone.
Is there a distinction between a telephone line and a cable?
I'm sure there is some very technical definition that the FCC could explain.
From my own experience, a telephone line is a line that you can plug in with a little click on and stick it into receptacles. That's designed for telephone lines, and it would have to come from AT&T or whoever was a telephone provider. But I do know we have telephone regulations that nobody knows where they reach and how to what they apply. I get my telephone over computer, voice over computer from a cable company. Is that a telephone line?
You know, I think there is a distinction, Your Honor, because a lot of communications travel over the internet now. So these types of online fax services are internet-based. And that is something, again, that did not exist in 1991 when Congress had enacted this statute.
It's probably time to write your congressman.
That might be right, Your Honor, and that's exactly what the outcome was in this Facebook decision that I referred to, that although in a different component of the TCPA, the Supreme Court said you can't take this new technology and try to foist it into this 1991 statute that simply didn't contemplate this type of technology. And if you were to accept the definition that plaintiffs are advancing, then my iPhone would be a telephone facsimile machine. And I think that we all know that that can't be. Congress couldn't have contemplated that.
Well, if you're reading it broadly, I suppose it'd be, but I mean, if you start talking about any device that is capable of printing, then there's no limit.
That is absolutely true, Your Honor. I think it is really important, and this is what the FCC itself found when it issued the Merifactors order, that the statute says on the sending end, there are 3 categories of equipment that are in play: the telephone fax machine, the computer, and some other device that's capable of these things. When it comes to the receiving end, it's 1 category of device, the telephone facsimile machine. We shouldn't render that distinction superfluous. That distinction has meaning. And we all know that when we receive emails, those are received on our computers. So it was on that basis.
What's the difference between a fax and an email, unsolicited email?
Well, unsolicited emails are covered by a totally different statutory regime called CAN-SPAM. So it's not that there's no regulation there that protects.
I know, I'm not trying to say it needed to be regulation. I'm trying to find out when we're construing a statute and everybody gets emails, advertisements, and you sort of ignore them. But we're capable of printing them. My printers automatically connect to my computer. I can hit a button and it'll print. And the question is, can that be construed as a fax machine? And is that a fax because the advertising was sent from a computer?
I don't think there's any definition that Congress could have contemplated, and it's certainly not consistent with the statutory language, that an email is a telephone fax, is receiving a fax on a telephone fax machine. And FCC has been consistent in that position since 2003. When we receive an email, that's something very different. It's something on a computer. So here,
I think over the years, the FCC has shown some confusion in this whole area too. I mean, when they first start out, they want everything broad, and then they come later and they say, well, broad is too broad because of the integration of devices. It's who knows what's going to be in 10 years. We still have these statutes, and in 10 years, where the technology is going to be.
And that's why this should be a question for Congress. But I do think in the Merifactors order, the FCC explains that prior decision and says, well, wait a second, we were looking at technologies that were still functioning like that traditional fax machine, even if they're attached to a modem and they're
there's a difference. But I mean, there's a reason for the different definitions of the sender and the recipient. And that is when you get something over a fax machine, at least at the time that Congress was contemplating the statute. One of the annoying things is that the fax machine is inoperative while the machine is printing out literally sometimes hundreds of pages of descriptive material, and it's rendered useless. And it is extremely frustrating to stand in front of one of those machines and having to wait for all the materials to be sent out. I tap my foot and I twiddle my thumbs and I'm saying, come on, come on, come on. And it seems to me that it was that logjam that probably motivated the difference between the computer and the fax machine, to the extent that Congress was even aware of it. But the different in the definition, it's not nonsensical. It may be outmoded, but it seems to me it was not nonsensical at the time it was enacted. And you make the point that, you know, the question, who is going to lead us into the age of modern technology? And Congress can hold a lot of legislative hearings on the respective burdens that sending to fax machines and sending to computers through email. I think you can make a pretty good argument that sending to a computer, even if it's only email, and even if you have the option of printing it out or not printing it out, it still it's really annoying. But the question is it seems like an ideal subject for a legislative hearing. That's where that's why I have some difficulty with the plaintiff's position on this.
And the FCC did too, the expert agency that understands how the statutory regime and the rules promulgated thereunder are intended to operate and what they're intended to apply to.
How
The
are we
law-
supposed to take that opinion, the FCC opinion?
Look, the law didn't change. The technology did. And
I'm talking about what role should it play in our decision making?
may I answer, Your Honor? I see that I'm out of
Yes,
time.
please.
The easiest application would be Chevron deference, Your Honor, because
Chevron deference.
that would be the easiest application. If there is accepting plaintiff's argument that e-faxes or internet faxes just might be contemplated by the statutory language, which the court is surely free to say, no, the plain language doesn't contemplate it. But if you were to give any credence to the argument that maybe that was contemplated, then we have an ambiguity. And the ambiguity was resolved through the FCC's Amerifactors order after a formal notice and comment period in which the plaintiff participated.
The problem is, counsel, that Chevron deference is it's kind of falling out of favor with the Supreme Court. And what is coming into favor is the plain language and text and the rest, and the Chevron deference and the Skidmore deference, but particularly Chevron deference, is falling out of favor with the Supreme Court because it's handing over, it's judges handing over too much authority to the administrative state. Now, whether you agree with that or not agree with it, that is problems. Whereas a plain language and a textual may have more resonance.
I see I'm out of time. My final comment is that I think there are a lot of ways to get to an affirmance, and the FCC's decision is consistent with the statutory language. So that would certainly justify this court to agree with what FCC did and said, yes, the plain language means
Let me
what.
ask you one question. It's a definition one. I'm not familiar with the definition of an e-fax. What is an e-fax?
Well, in the internet-based fax that results in an email, not that automated printout on
What's the
paper.
difference between what I receive on a computer and an e-fax? If I receive a solicitation for somebody to buy something or sell something, is that an e-fax?
One of the things that the FCC did in the Amerifactors order is review the different types of technologies. But what they reviewed is that the origination of a communication that could be received by a telephone fax machine or could be received on your computer just as an email.
Then it's just a straightforward email. Why is it an e-fax? I suppose it could be an e-fax if it's sent from a fax machine to my computer. But if it's sent, most of these things that are generated these days are done by computer. You upload whatever you want and you send it out, and you send it to telephone numbers that are connected to fax machines, or you send it to telephone numbers connected to computers or cell phones, whatever you do.
That's right, Your Honor.
I heard you use e-fax and I saw it being used and I couldn't understand what an e-fax is.
Yeah, I think that there's a lot of different ways to describe these emerging technologies that are far
I'm
different
not talking
than,
about technology. I'm just talking about the pragmatic matter is when I receive an e-fax and when I receive an email. Is there a distinction?
no, it's the same. It's an email. You're
All right,
receiving
thank
an
you.
email.
So you're just talking past us.
I apologize.
You're speaking beyond us when you use those terms.
I apologize for that, Your
No,
Honor. It's-
they're ambiguous. They're ambiguous.
Arguably, Your Honor, and if, well, those terms are ambiguous, but it doesn't make, that's different than whether the statute is.
E-fax, does it?
That's correct. And,
Yeah.
and it, nor could it, because those technologies absolutely did not exist in 1991. They came much later, and they certainly didn't come into prevalent use until about 20 years later. Thank you, Your Honors.
All right, thank you very much. Mr. Har, we're happy to hear you in rebuttal, sir.
Thank you, Your Honor. Regarding the terms e-fax, online fax service, they're the same thing, which is what's so bizarre about the AmeriFactors Bureau rule. Because from the 2003 commission order.
So just stick with that for a second. What is an online fax or an e-fax?
An online fax service is defined Bureau order. It's a long definition, but it entails telephone, faximile machine, computer, or other device that sends to a fax server or other device text or images.
What if I receive it on my computer?
Well, it depends on how you're using the computer, because a fax is sent to
I
attention.
have a computer at home, and I get every day, I get hundreds, I don't know, hundreds. I get a whole list of advertisements promoting something, and they send that over there. I can print that advertisement. As a matter of fact, I have printed it when it's a gift or something, and I look at a picture and I print it. Now, is that a fax?
If it was sent to your email address, then it is an email. It's sent to an internet address, not to a 10-digit telephone number. Faxes are sent to 10.
Okay, how about if it's sent to my telephone number and I get it as a text? And I can download that text on paper. My telephone, my iPhone is connected to other persons by telephone number. And people send me things and send it through a telephone number. And I receive it. And I receive documents and see pictures. And I download it. I can download it. I mean, I can print it. Is that a fax?
No, it's not, because text messages are covered by a different section of the statute.
I know, but I understand. I'm trying to ask you what the difference is. When I'm understanding, you keep using, she used it too, it's e-fax and online fax. I don't know what a fax is, except in the historical context. I do understand what the historical fax is.
FCC has been dealing with these issues for 25 years. They're all covered in the 2003 commission order, paragraphs 199 through 201, and in the 2015 West Fax Bureau ruling. That it was specifically that was a petition filed by.
I'm not asking the commission at this point.
But they analyzed the statute. That agency is expert in.
And what deference does we give to them?
Well,
in that order you're just pointing to, put your hand on.
yes, the 2003 commission order.
What deference is that? Chevron?
If PDR Network 1, this court's first decision in 2018, is still good law, even though it was vacated by the Supreme Court in PDR Network 2 and remanded, then it's binding on the district court, because this is a final order of the FCC. It is not a bureau order that's currently on appeal like the AmeriFactors Bureau ruling. So if that case is still good law, then the 2003 order is binding on district courts, and it means that fax servers that then convert the fax into a PDF or other
When you
document,
say binding, what do you
email
mean?
it, is binding.
Couldn't a district court conclude that that order doesn't follow the statute?
It depends on the Hobbs Act question, actually. This court held in PDR Network 1 that the answer is no. A district court's not allowed to do that because circuit courts of appeal have exclusive jurisdiction to determine the validity of final orders of the commission. That was the issue that was before the Supreme Court in PDR Network 2. The Supreme Court declined to answer that question and remanded to this court to decide 2 preliminary questions, which it subsequently did in PDR Network 3. And one of those holdings is that interpretive rules are subject only to Skidmore deference, not to Chevron deference. So if PDR Network 1 is still good law, then the 2003 commission order is binding in the district court. And the district court has to be reversed because there is no distinction between online fax services.
Counsel, taking up, putting aside the questions, I think the dialogue between the court and counsel has indicated the difficulties of sometimes deciding what is what. And I'm wondering if a certain deference isn't due to, it's under an abuse of discretion standard, and if a certain deference isn't due to a district court in deciding whether to certify the class. After all, these class actions present sometimes very difficult and extensive questions of practical administrability. And a district court's got to do that. And if a district court looks at all of the evidence and say, you know, I really think that the individual circumstances here are predominant, or they're difficult to untangle, or whatever. But on those questions of administrability, isn't a trial court's judgment on certification of a class due a considerable amount of respect?
It's an abuse of discretion standard, Your Honor, but a district court abuses its discretion when it relies on erroneous legal conclusions. That's the applicable standard here on review. And the erroneous legal conclusions that we pointed out are, you know, that the AmeriFactors Bureau order is a final order for Hobbs Act purposes. It's clearly not. It's not final. It's on appeal right now, and it's not of the commission. And second, that even if it is a final order, that it's binding on district courts. We argue that that is wrong. But if the court disagrees and holds that final orders are binding, then it's the 2003 commission order that's binding here. The third error is that even assuming it's a binding order, that the AmeriFactors Bureau rule can be applied retroactively. The faxes in this case were sent in 2016, 3 years before the AmeriFactors Bureau ruling was issued. The Sixth Circuit held in the Lingas case that the rule can't be applied retroactively like that. The Sixth Circuit affirmed a class of all fax recipients, regardless of whether they were using online fax services or standalone fax machines or whatever. It was all fax recipients. As you know, dozens, hundreds of TCPA fax cases have been certified over the years, and the courts have always rejected this distinction. And the FCC always rejected the argument that there was a difference between e-faxes or online fax services or something, or fax modems or fax servers. It's broadly construed, the statutory definition of telephone facsimile machine, to cover all of that equipment, because the purpose of the statute is protecting consumers. It's not letting junk fax advertisers off the hook on a technicality. They don't know when they're sending a fax whether it's going to be received by a standalone fax machine or by an online fax service that then forwards it to the end user on a computer. They shouldn't get the benefit of the doubt. Now, there's also the ascertainability issue, which we filed an initial petition for hearing en banc on it to change the standard in this circuit. I'm not going to address that here unless, you know, I have to file a petition for rehearing en banc on the issue. But
all right, thank you very much.
thank you.
Ms.
Thank
Mazzuchetti, we notice you've reserved 2 minutes for rebuttal, but do you have something to rebut rather than introducing a new argument?
A few minor points, Your Honor. That Lingas decision, the Sixth Circuit decision that plaintiff relies upon, even as there was no briefing before the Sixth Circuit on the AmeriFactors order or how it should be applied. A subsequent Sixth Circuit panel noted that and questioned what the Lingas court had actually ruled. With respect to
how do we take that opinion? What's your position on that? Is that a final order of the commission?
Is the AmeriFactors
Yeah.
order? It is certainly an effective and not tentative order. So, you know, under,
What's your position?
and it's a final order, Your Honor. I acknowledge there's an application for review that is pending. I will note
The
that
commission hasn't ruled on it yet, has it?
it hasn't, and it may never. The
So what makes it a final order of the commission?
the CFR regulations indicate that orders of the Bureau of the Consumer and Governmental Affairs Bureau are effective upon release. And on that basis, 2 Northern District of California judges, Judge Gilliam and Judge Bailey in Jeffrey Katz Chiropractic and case involving McKesson both ruled that it was a final order because it was non-tentative. And that's the same type of analysis that Judge Childs applied here.
All right.
One
Is that-
final. Sorry, Your
Yeah,
Honor,
yeah.
I interrupt. Final point as to retroactive application, the law didn't change, the technology did. And as you know, the FCC has always ruled that an email is not, receiving an email is not receiving a fax on a telephone facsimile machine. As technologies evolved over time, there were all these hybrid things. There were technologies that functioned just like that telephone facsimile machine and printing out. And then they really came fully to an email solution. Faxes aren't traditionally received anymore on something that spits out paper, and what Congress intended in
I think
1991
our
is not
office
covered.
still has a fax.
I'm sorry?
I think our office still has a fax. What does that make us?
It's okay. Many doctors' offices and folks in the medical sphere continue to use fax machines because it is a very secure way of communicating, very expensive way of communicating too, because of the toner and the paper and all the things that Congress was concerned about. But it's pretty limited in use at this point, Your Honor.
All right, thank you very much. We appreciate both of your arguments, and we will adjourn sine die, and we'll take a 5-minute break, and then we will have the court reconvene in conference.
This honorable court stands adjourned, sine die. God save the United States and its honorable court.